Welcome to NYPTI's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nypti.com/law to read the full decision.
People v. Elijah Carnegie, number 50, People v. Anthony Dockery, number 51, decided May 28, 2026. Garcia, J. Both defendants committed sex crimes when they were below the age of 20 and now challenge their risk level designations made pursuant to the Sex Offender Registration Act, SORA, Correction Law Art 6C, arguing that the lower courts should have considered their young age at the time they committed these offenses as a basis for a downward departure from their presumptive risk level. Not so. Courts may only grant a downward departure request where there is a mitigating factor not adequately taken into account by the Risk Assessment Instrument, RAI. The RAI created by the Board of Examiners of Sex Offenders, the Board, in the Sex Offender Registration Act, Risk Assessment Guidelines, and Commentary, the Guidelines, treats young age at the time of the offense as an aggravating factor, and so provides for the assessment of 10 points in calculating the presumptive risk level where an offender's first sex offense was committed at the age of 20 or younger. Accordingly, because age at the time of an offender's first sex crime is accounted for in the RAI, 10 points are assessed when an offender is under 20, the courts below did not err in refusing to consider defendant's young age at the time the crime was committed as a mitigating factor, and the appellate division orders should be affirmed. 1. In Carnegie, defendant pleaded guilty to the gunpoint rape of an 18-year-old woman committed when he was 19. He was sentenced to 6 to 12 years in prison in North Carolina. He was approved for a transfer of his parole to New York, where the board prepared a case summary and RAI assessing him 85 points, including 10 points under Risk Factor 8, based on his age, below 20, at the time he committed the offense. Defendant sought a downward departure, asserting that scientific research shows that young age at the time of offense reduces the likelihood of recidivism, and that his strong family support and stable employment would also reduce that risk, and that all these circumstances were mitigating factors not adequately taken into account by the RAI. Defendant's submission included research studies as well as a letter from his father. Supreme Court rejected the request for a downward departure and adjudicated defendant a Level 2 sexually violent offender, noting that the Board of Examiners has not amended the risk assessment instrument and defendant's age was adequately taken into consideration by the instrument. The appellate division affirmed, holding that Supreme Court properly designated the defendant a Level 2 sex offender. That court held that the alleged mitigating factors consisting of the defendant's supportive family and his young age at the time of the commission of the subject sex offense were adequately taken into account by the guidelines, and that, moreover, the defendant failed to demonstrate how his family support established a lower likelihood of reoffense or danger to the community. As to the defendant's age of 19 years at the time of the sex offense, the court concluded, an offender's age of 20 or younger at the time of the offense is deemed to be an aggravating factor rather than a mitigating factor. In Dockery, when defendant was 18, he attacked 2 women within a 2-month period and was convicted by a jury of robbery, sexual abuse, assault, and attempted rape. He was sentenced to 24.5 to 50 years of incarceration. In advance of his release in 2023, the board prepared a case summary and RAI assessing him 125 points. Like the defendant in Carnegie, he sought a downward departure, making the same argument that young age at the time of offense reduces the likelihood of recidivism, and that his strong family support would also reduce that risk, and therefore that these circumstances were mitigating factors not adequately taken into account by the RAI. Defendant's submission included research studies as well as letters from his father, aunt, 2 siblings, and niece. Supreme Court rejected defendant's request for a downward departure and adjudicated defendant a Level 3 sexually violent offender. The court noted that the RAI provides for the addition of points for the commission of a sex crime at a young age and does not permit that fact to be used as a mitigating factor. That defendant had not shown how the strong family support will prevent the defendant from reoffending, and that family support was already taken into account by the RAI. The court went on to hold that even if there were mitigating factors not accounted for by the RAI, defendant had not met his burden of proof to establish that those factors are present in his case. The appellate division affirmed, holding that defendant's age at the time of the offense was adequately taken into account by the guidelines, that the support provided by a family member with whom the defendant intends to reside is adequately taken into account by the guidelines' consideration of living arrangements, and that, with respect to the support offered by other family members, the defendant failed to adequately explain how their support will contribute to a lower likelihood of reoffense or danger to the community. This court granted leave to appeal in both cases. 2. SORA directs the board to develop guidelines and procedures to assess the risk of a repeat offense by a sex offender and the threat posed to the public safety. Correction Law, Section 168-L5. The RAI, the board's response to this mandate, provides a method for calculating an offender's presumptive risk level, which the board uses to make a recommendation to the court providing for one of 3 levels of notification. Correction Law, Section 168-L6. The court must then make a determination with respect to the level of notification, by either accepting the board's recommendation or rejecting that recommendation in favor of a different risk level classification supported by the evidence presented at the hearing. People v. Gelati. The guidelines provide that the board or a court may not depart from the presumptive risk level unless it concludes that there exists an aggravating or mitigating factor of a kind or to a degree that is not adequately taken into account by the guidelines. Departures in either direction are the exception, not the rule, and are merited only if special circumstances warrant. The board has included in the guidelines several illustrative examples of mitigating factors based on circumstances described in Correction Law Section 168-L5 that may warrant a downward departure, explaining that, for example, if an offender's presumptive risk level is 3, but he suffers from a physical condition that minimizes his risk of reoffense, such as advanced age or debilitating illness, a downward departure may be warranted. See Correction Law Section 168-L5D. Whether a departure is warranted is assessed by a court pursuant to the 3 analytical steps set out in Gelati. Guidelines at 4.7. See also People v. Weber. Where the hearing court's findings, expressly made under the proper evidentiary standard, are affirmed by the appellate division, this court's review is limited to whether the decisions below are affected by an error of law or are otherwise not supported by the record. People v. Perez, quoting People v. Lashway. The issue here falls within Step 1 of Gelati, whether young age at the time of first offense is, as a matter of law, a mitigating factor not adequately taken into account by the RAI. SORA instructs that the RAI must be based, in part, on a non-exhaustive list of conditions related to the potential risk of reoffense, People v. Francis. These factors, set out in Correction Law Section 168-L5, include several criminal history factors indicative of high risk of repeat offense, such as the age of the sex offender at the time of the commission of the first sex offense, In accordance with this statutory mandate to consider age as indicative of recidivism, the guidelines provide for the imposition of 10 points if an offender's first sex crime, whether a felony or misdemeanor, was at age 20 or less, because it is a factor associated with recidivism. Those who offend at a young age are more prone to reoffend. Guidelines at 13. Defendants' argument that scientific research suggests that young age at the time of offense lowers the risk of reoffense and so is a mitigating factor meriting a downward departure amounts to a policy dispute with the legislature's instruction to the board to consider that factor, and with the board's corresponding decision to include age below 20 at the time of first offense as a basis for the assessment of 10 points in the RAI, not an argument that the RAI does not fully capture the nuances of their case. Guidelines at 4. It is the board that has a legislative mandate to promulgate the guidelines, People v. Moss, and disagreement with the basis on which a factor is premised or with the manner in which the board implements that mandate is for the legislature and the board to consider and not within the scope of this court's authority. Francis. Indeed, the constitutional principle of separation of powers requires that the legislature make the critical policy decisions, quoting Birkin v. Cuomo. Here, the legislature did that by instructing the board to consider as indicative of a high risk of repeat offense the age of the sex offender at the time of the commission of the first sex offense. Correction Law Section 168L 5A-V. The board, based on its expertise and experience and within the exercise of its discretion, in turn implemented this legislative directive by requiring the assessment of points under Risk Factor 8 where an offender committed a first sex offense before the age of 20. See Francis. There is no legal basis for reaching the opposite conclusion in the guise of a judicially fashioned mitigating factor. The legislature, and in turn the board, may of course reconsider this approach to age as an indicator of likelihood of reoffense. Accordingly, the lower courts properly held that defendants' young age at the time of offense was adequately taken into account by the RAI, and there was no need to proceed to the next step of the Gigliotti analysis. 3. Family support and stable employment are, as a matter of law, mitigating factors not adequately taken into account by the RAI and so must be assessed under Step 2 of the Gigliotti analysis. See People v. Green, decided today. Here, while rejecting defendants' downward departure requests on the basis that family support and, in Carnegie, stable employment are not mitigating factors, the lower courts went further and analyzed these additional factors under the proper legal standards set forth in Step 2 of Gigliotti, considering whether the party requesting the departure has adduced sufficient evidence to meet its burden of proof in establishing that the alleged mitigating circumstances actually exist in the case at hand. Therefore, remittal is not required. Accordingly, in each case, the order of the appellate division should be affirmed, without costs. For number 50, order affirmed, without costs. Opinion by Judge Garcia. Judges Rivera, Singis, Canataro, Troutman, and Halligan concur. Judge Halligan in a concurring opinion in which Chief Judge Wilson and Judge Rivera concur. For number 51, order affirmed, without costs. Opinion by Judge Garcia. Judges Rivera, Singis, Canataro, Troutman, and Halligan concur. Judge Halligan in a concurring opinion in which Chief Judge Wilson and Judge Rivera concur. Decided May 28, 2026.
Welcome to NYPTI's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nypti.com/law to read the full decision.